Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to our latest podcast number 123. We've got a slightly different approach today in that I've got two cases to deal with and then some thoughts on a news article which got me thinking. All will become clear. Of the two cases, we've got one case which deals with the challenge to the fairness of a dismissal because of the content of the investigative report. And then we've got a case on territorial jurisdiction clauses and contracts of employment. As usual, you can access the podcast via iTunes, the Mayor Brown website, it's on YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11. And that's, of course, also, as you know by now, where we put out all the links to the cases. Not quite figured how we'll deal with the link to the news article. Let's see how we get on with that. Anyway, first case, NHS 24 and Pilar. And this case relates to an unfair dismissal claim where the employee objected to certain material being put into the investigative report, which then went to the disciplinary manager. Background is that the claimant is a nurse practitioner and she was working for NHS 24. Her work involved taking telephone calls from members of the public and then taking a decision on the most appropriate clinical outcome for that caller. There was an incident in December 2013 which NHS 24 identified as a patient safety incident, a PSI in the jargon. She was dismissed because of that PSI. At the time of the incident, the claimant had been responsible for two previous PSIs, one in 2010 and one in 2012. After the 2010 PSI, the claimant was put on a development plan. She was not told that a repeat by her of similar conduct would potentially have disciplinary consequences. After the incident in 2012, she was again required to follow a development plan, but again did not face disciplinary action. And we don't have a lot of detail about the earlier PSIs, but I don't think that the PSIs were identical to the particular PSI in 2013. So the primary issue was the fact that there were previous PSIs. Well, the investigating officer who was looking at the 2013 incident prepared a management report for the disciplinary manager and included details of the two previous PSIs from 2010 and 2012, what had happened, what the outcome was, what her conduct was, etc. As a result of that, the disciplinary manager gets that material and then goes ahead and makes a decision to dismiss because the dismissing manager says this is gross misconduct, this is worth a dismissal. The Employment Tribunal hearing, which then followed because she brought a claim for unfair dismissal, felt the dismissal was unfair. This was because the earlier PSI incidents had not resulted in disciplinary proceedings. But the tribunal said it would have been acceptable to have included information on the training and development plan that was implemented following the earlier PSIs, but not to have included details of the PSIs themselves. Therefore, the tribunal concluded the investigation had not been conducted fairly. On that basis, the Employment Tribunal decided the dismissal was unfair because, quote, the investigation was not in the band of reasonableness, unquote. It was also found to be unfair by the tribunal because the employer was felt not to have been sufficiently transparent with the claimant to alert her to the fact that any repetition of the behaviours following after the 2010 and 2012 PSIs might result in a disciplinary process. However, and somewhat confusingly, the Employment Tribunal did find that the decision to dismiss itself was fair because it was reasonable for the employer to treat this matter as gross misconduct. Quote, on the material before her, which included the information on the previous incidents, given the potential risk of patient safety, the decision to dismiss was within the band of reasonable responses, unquote. So on the one hand, the tribunal was saying that the material should not have been included in the investigative report, but on the other hand, saying that the decision to dismiss, based on the investigative report, was fair. Well, the EAT overturned the tribunal's decision and substituted a finding that the dismissal was fair. It did not remit the case back for a reconsideration by the tribunal. First, the Employment Tribunal had accepted that a decision to dismiss in the circumstances of the 2013 PSI would have been fair. In other words, it was the inclusion of the earlier incidents that in the investigatory report that had rendered it unfair. It was perverse to find the dismissal unfair on the basis that the 2 earlier PSIs had been included in the investigatory report. The job of the investigator was simply to assemble information for an investigation report. It's not up to the investigator to decide on what weight to attach to particular pieces of evidence. Equally, the leading case, BHS and Birchall, merely requires the investigation stage to be sufficient. Quote, the purpose of the investigation was to gather all relevant materials so that the officer making decisions could decide all factors pertinent to the issues of dismissal, unquote. Whether to rely to any extent on past conduct was a matter for the disciplining officer. Here, the EAT said it was clearly a very thorough investigatory exercise, and the EAT accepted that in theory there could possibly be unfairness caused by an overzealous investigation process. That wasn't the case here. And secondly, the EAT pointed out they were not considering here whether it was unfair to take into account the earlier PSIs in deciding to dismiss for the 2013 PSI. The Employment Tribunal had accepted that bit, the dismissal stage, did not make the dismissal unfair. Separately, the EAT accepted that the claimant had not been given any expectation either way about what would happen if there were further PSIs. Therefore, there was no suggestion they hadn't been sufficiently transparent. A separate ground of appeal also succeeded. The tribunal had found that there had been procedural flaws in the dismissal process, but had made no attempt to explore the content or gravity of the procedural defect. As the EAT pointed out, if there is no real relationship between the procedurally unfair step and the ultimate outcome, then the impact of the procedural defect may be very limited. It certainly did not follow that because there had been a procedurally unfair step, then the dismissal was necessarily unfair. I wanted to include this case because it does look at an aspect that only comes up occasionally, but I think is important, and that is what should go into the pre-disciplinary investigative report. Normally, of course, if there is a challenge to such a report, it's because it's not been thorough enough, or has left out things that the employee says should have been included. Here it was including potentially irrelevant material, in the view of the claimant. Since the decision to dismiss based on that material was no longer being challenged by the time the case got to the EAT, it is difficult to see how including potentially relevant material in an investigatory report could ever render that dismissal unfair. Nonetheless, I do think this is a useful lesson for an employer. It does need to think, if they're commissioning investigation ahead of potential disciplinary action, whether material does properly belong in the investigatory report. Clearly, if irrelevant material is included and is then relied on by the disciplining manager, that may be unfair. However, the danger for an employer is that the disciplining manager may feel that he or she is entitled to take into account material wherever it is in the investigative report. The EAT's decision makes clear that the investigator's report and job is to assemble potentially relevant material and evidence, but it's for the disciplinary manager to decide what is particularly pertinent to the outcome of the disciplinary hearing. And it's also useful, I think, to have another reminder that just because there is a procedural defect in the context of a disciplinary process, that does not necessarily render the dismissal unfair. It's necessary to look at the impact the unfair step had on the overall outcome. So, that's the case of NHS 24 and Pilar. Next up, Nogueira and Crewlink Limited. This is a case on territorial jurisdiction clauses and contracts of employment. It represents an attempt by Ryanair to require its employees who have never lived or worked in Ireland to bring any employment disputes in the Irish courts. The case made its way up to the European Court of Justice, and although it relates to air crew and airline workers, the points that it makes are generally important and in no sense restricted to the aviation or travel industry. The Brussels regulations and the updated version, the recast Brussels regulations, set out a series of jurisdictional rules to determine which countries' courts have jurisdiction to determine which disputes. Although this particular case considered the Brussels regulations, there's no material difference in relation to the new recast Brussels regulations in this area. There are specific provisions relating in the regulations to employment contracts, since these are an exception to the general rule that a defendant must be sued in their country of domicile. For employment contracts, however, the employee may choose to sue in the country where the employee habitually carries out their work. If there's no single country where they habitually carry out their work, then the employee may sue the employer in any country where the business which engaged the individual is situated. The claimants were employed by Crewlink, which is an Irish company, part of the Ryanair Group. The contracts of employment were in English, purported to give the Irish courts exclusive jurisdiction over any employment disputes. However, under the contract of employment itself, the home base for these claimants was at Charleroi, an airport near Brussels, As a matter of fact, the claimants started and ended their working days at that Belgian airport. They were given instructions on the tasks they were to perform on any given day when they were at that airport, and any disciplinary proceedings started at that base, although the latter stages might be conducted in Ireland. Following the ending of their employment, the claimants sued in the Belgian courts, asserting that the Belgian legal system had jurisdiction to determine the dispute. Ryanair disputed this, and the matter ended up in front of the ECJ. The European Court of Justice upheld the employees' claims and said that the contractual clause, which asserted that the Irish courts had jurisdiction, was not valid. The question of which court of jurisdiction had to be determined by the provisions of the Brussels regulations. Secondly, the court said that where there were multiple countries in which the claimants worked, typically in the transport sector, it was permissible to look at the country, quote, from which, unquote, they carried out their obligations. Although the ECJ is not entitled to determine definitively that the Brussels courts are the relevant courts for the purpose of determining this dispute, they pointed out that the nomination of a home base in the contract, in Belgium, the place from which the employee started and finished, Belgium, the place where the employees received instructions and work to be undertaken, Belgium, the place where their work tools were situated, the aircrafts were at the airport, in Belgium. These are all relevant factors. On that fact, in this case, this all points to Belgian jurisdiction. Now, this is all in accordance with the finding that the reason for an exception to the Brussels regulation on matters of jurisdiction for employment contracts is that the employee is the weaker party in negotiations with the employer and therefore needs to be adequately protected by the law. It's fairly common to find jurisdiction clauses contained in contracts of employment for employees who are globally mobile. That's generally a good idea. But the Ryanair case is a good example of the limitations of such a clause, which purports to give exclusive jurisdiction to the courts of a country viewed by the employer as, presumably, employer-friendly. Such a clause cannot override the Brussels regulations, and so it is of strictly limited impact. Unless the clause is entered into by agreement with the employee after the dispute has arisen, the employee cannot be required to comply with the contractual jurisdiction clause, which requires them to sue in a different country from the one identified in the regulations. Given the particular challenges applicable to the transport sector because of the number of countries in which employees work, it's also quite helpful to note that employees may sue in the country from which they work. Therefore, an employee, such as a member of an aircrew, who travels but sets out from a particular location regularly, can then anticipate being able to bring a claim in that country's courts. I anticipate employers will carry on putting jurisdiction clauses in contracts of employment. As I say, they're a good idea. Sometimes employees may be happy to go along with them. Sometimes they may do no more than state the Brussels position as to which courts have jurisdiction. Sometimes an employee may, in the absence of legal advice, believe that they have to comply with that clause, even if the Brussels regulations might produce a different result. Equally, however, employers should generally know that attempts to stop employees suing in their own home country or in the country in which they're based are likely to be fruitless. The Advocate General, who provided an opinion before the decision of the European Court of Justice, came to the same conclusion for largely similar reasons. The Advocate General had identified 6 factors which pointed to the decision that the Belgian courts had jurisdiction. The fact the individual started and ended their working day at the Charleroi airport was of, quote, overriding importance, unquote. They received their instructions at the airport. The fact that the instructions had been given by managers while the managers were based in another country was not relevant. And the fact that the airports to be crewed by the claimants were at the Belgian airport when the employees turned up for a day's work was relevant. Individuals were contractually required to live within an hour's travel of Charleroi Airport. There was a crew room at Charleroi Airport, so it was an office made available for work purposes. That was relevant. And indeed, there was a clause that said that the employees had to attend Charleroi Airport if they were unfit to work, to register that unfitness, or if there were disciplinary problems. On that basis, the Advocate General's view was that the 6 factors, quote, unequivocally designate, unquote, the Belgian courts as the relevant courts. So the Advocate General clearly went far further than the European Court did in suggesting the outcome. So that's the case of Nogueira and Krulink. Now, third and finally, I wanted to just say a few words around a speech that I saw, a report of a talk by Justine Greening, the Minister for Women and Equalities. And the gist of the story was that she was encouraging employers to report early on the gender pay gap statistics. She pointed out that only 1% of companies who are going to be required to report on their pay gap stats have in fact done so. And she said that companies should give a timeline, and those who have not responded should have a timeline that says when they intend to respond between now and 31 March 2018, by which date they have to have responded. All of which got me thinking. First, the furore that has greeted some of the gender pay data which has been published early by companies scarcely encourages companies to stick their head above the parapet sooner than is necessary. Secondly, however, the critical issue of what to publish is also linked to when to publish. I had always assumed, without having thought about it specifically, that most companies would delay matters until January or February next year. So I'm not particularly surprised to see that only 1% of companies have reported so far. However, thinking about this in a bit more detail, I think the question about when an employer is going to publish its statistics, together with any action plan or supplementary information, is a key one. I could quite see that employers might be reluctant to publish early, because at the moment it is a very small pool indeed of employers, and any credit you'd get from publishing early might be overwhelmed if the statistics are poor. Just ask the BBC for any doubt about that one. However, equally I can see that companies that publish on 30 March 2018 may also attract a fair amount of criticism, particularly if their statistics are poor. The trick is going to be to publish at the right point, particularly when enough other employers are publishing statistics, so you're not going to be newsworthy. So the conclusion that flows from that is obviously going to be to ensure that you're ready to publish your statistics and background information / context as soon as possible, but keep a close eye on the government website for when the stats have been published by your competitors, others in the sector, and generally UK employers. Now, clearly some people may object and say the purpose of the statistic reporting is to encourage employers to embrace diversity and correct pay imbalances. Companies should be seen to publish and embrace the need to make changes. But this is entirely right, of course, but it brings me on to the second point. The way that the gender pay gap reporting rules have been organised, it's a very blunt instrument. By themselves, the pay gap stats are a very limited guide as to whether employers are paying men and women fairly for the work they are doing when compared to each other, i.e., they have a very limited guide as to whether or not the employer is actually paying equal pay for equal work. An organisation which employs gender-neutral recruitment policies, but which tends to attract more women into its junior ranks and more men into the senior ranks, will probably have a very poor set of gender pay gap figures. An organisation that pays bonuses in April, assuming for a second that larger bonuses go to more senior employees who are more likely to be male, will have worse pay statistics than one who pays exactly the same sum in bonuses in March or May. None of which is any sort of guide as to whether there are equal pay issues lurking underneath the surface. Of course, if you believe the government knew what it was doing, the impact of having such an unsophisticated set of statistics is to encourage companies to engage with those statistics and explain them by putting them into context, and at the same time, presumably promising improvement if the statistics are not good. I therefore think that companies should be giving careful thought as to what the statistics show and do not show, and equally companies will have to consider what other statistics to provide, or an explanation of where there are significant differences, which in truth are nothing to do with gender. Another point to bear in mind, however, is that there may well be industry figures available for gender pay gap, or competitors may publish gender pay gap figures which may cast an organisation's figures in a good or a bad light, depending on how the organisation compares to those competitors' figures or the industry norm. Certainly, if employers have not done their pay gap analysis by now to have an indication as to how the statistics are looking, time is running out fast. The pay gap statistics are only the first part of the exercise, and the much more time-consuming one, and as I've indicated, is the message that goes around it, who it's communicated to, exactly what steps are being taken. Companies need to work out a communication plan. This may need to be a nuanced one. Will the same communication plan serve for investors, for third parties generally, on the website available to all? Will it serve as the communication plan internally for employees who are directly affected? I expect many employers will think about giving different levels of information to different groups. Obviously, it's all got to be consistent. But in the light of Justin Greening's comments, I do think employers will also need to be thinking quite carefully about when to publish their results. I would be really interested if anyone is working on pay gap stats at the moment and their thoughts as to when employers are going to start publishing. In particular, are employers planning to hold off until January or February next year, or do we think we're going to see a whole series of employers reporting this side of Christmas? Obviously, if I get enough feedback, I'll follow up on this in the next podcast. Rest assured, I'm not going to mention anyone by names, either as contributing or certainly not any company names. But in general terms, if people out there have got views, I'd be really interested to hear them. So that brings us to the end of another podcast. Thank you very much for listening to podcast 123. I think it only remains for me to confirm that in the making of this podcast, no gender pay gap statisticians were harmed or mistreated in any way. Thanks very much for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.